Okay, so we're back at the Office of the Law Revision Council, United States Code website. And in this video, I'm going to talk about remedy. So I've showed you the um, titles that have a positive law citation and the titles that don't have a positive law citation. One of them without a positive law citation is Title VI Domestic Security. Title 26 Internal Revenue, Hospitals and Asylums, and so many other ones, right? So you're probably, if you're watching this video, you're pretty familiar of these titles that I go over. Which ones have a positive law citation? Which ones don't? Every law has to have a way in which it is cited to be considered a law. Okay, so if it doesn't have a citation in it, it cannot be cited properly as a law. And in our form of government, or the United States, there's a positive law citation, which tells us that this law is going to be cited in exactly this way. Stick with me here because I know I just went over this stuff in another video that I posted today and many other videos that I've done, but we're going to talk in this video about remedy. Okay, and you won't hear it from me, you'll hear it from someone else. I'm just going to explain the details, as many of them as I have that are necessary for you to understand this. So, this is the positive law citation. This title has been made positive law by Section 1 of Act July 30, 1947, which provided in part that Title I of the United States Code, entitled General Provisions, is codified and enacted into positive law, keyword law, and may be cited as 1 USC subsection whatever. Every single title that has a positive law citation in it is law. Okay, this is Title III. You notice I skipped Title II because Title II does not have a positive law citation. There's cited as, it must be cited as 3 USC subsection. Now, if you go to any of these titles without an asterisk, there's no positive law citation, including Title II Congress. You can go through here and there's no positive law citation. I refer to these titles without a positive law citation as contracts and as social contracts. And I'll tell you here in a few minutes what they're also considered. The public lands have no positive law citation. Public health and welfare have no positive law citation. Telecommunications, territories, insular possessions, war and national defense, voting, and elections has no positive law citation. It's not a law. It's because it's not a law. The courts do not administer justice when it comes to issues that are not law. So what do they do? Let's see if I can remember it. Title 3, Chapter 1, 204. Okay, what is it? Repealed. I need 204. Repealed. Let's see. It was Title 4. No. That was in Title 3, Title 3, Chapter 1, Section 204, Chapter 3, been repealed. Title 1, Chapter 3. Here we go. This is where it is. Section 204. All right. Sorry that took me so long. Codes and supplements as evidence of the laws. Evidence of the laws. How do courts know that a title, when they're administering an issue, that the title or the thing that is in front of them that the lawyers are using to plead their case, that it's an actual law and not a contract or a social contract or something else, which I'll tell you in a minute. I figured out what it was, and I'll tell you how I figured it out. You can go and look it up for yourself. So, in all courts, tribunals, public offices of the United States at home or abroad, the District of Columbia, and each of the states, territories, insular possessions, such United States Code, so and so, provided, however, okay, so establish prima facie, that means on its face. What do we mean by on its face? Right up front, on its face. Proof of the law having been made. Proof of the law having been made is right here. It's the positive law citation. Proof of the law having been made. Prima facie, on its face. It's right here. It's right on the front. Prima facie evidence. Can't miss it. It's right there. Of the law having been made. Title 26. Don't matter, just like all the other ones. No positive law citation. No way to cite it. No way to cite the law. The law citation is required. It's required. You have to have the law citation. There isn't one because Title 26 is not a law. Okay. Prima facie, the laws of the United States, general and permanent, in their nature, in force, so and so, such and such, provided, however, and that means that they have to be made properly. They have to be spoken. They have to be passed through the houses. It has to be signed by the president. All the things have to be done for the law to have been made, including the right to make the law and the right people making the law. Provided, however, that whenever titles of such code shall have been enacted into positive law, the text thereof, meaning everything written in title whatever, shall be legal evidence of the laws therein contained, or all the courts of the United States and the several states and the territories and the possessions of the United States to see. Have to see it on its face. Prima facie. The citation is the evidence. The citation, the positive law citation, is the evidence of the law having been made. So when the issue comes to the court knows that it is administering a law and not interpreting a social contract. So let's look at something real quick. I don't have it for you to look at, but I have it to read. Let's see, page 59 in the book by LaRue, which I have told you guys all about, called Constitutional Law as Fiction. He's talking about Marshall and um, the issue with his appointment early on in after the Constitution was passed, and it was between him and another guy. So he says in here on page 59 of LaRue's book, Constitutional Law as Fiction, Narrative in the Rhetoric of Authority. He's distinguishing between appointments and commissions. He says appointments are political, commissions are governed by law. This is important. Now, Marshall uses the distinction between appointing and commissioning to separate the realms of politics and law. The act of appointing is the president's, and concerning it, his judgment and will is final, okay, because the president does not make law. The president does not legislate, he executes. And recall, I've talked about from Austin's book, How to Do Things with Words, the difference in the types of words and the types of acts. So legislators legislate, executives execute. So he's saying here that the president is appointing people and the legislature or the Congress commissions people according to law, or that commissions are performed by a process governed by law. Okay, if Marshall, quote, if Marshall can make this distinction plausible, then he can gain enormous rhetoric advantage from the distinction, because there is a distinction. There's a distinction between law, commissions done by the legislature, and Title 26, and I bring up 26 for a specific reason. Title 26, appointments, okay, not law. It's something else. We're going to talk about something else, but not law. Appointments are done by the executive, and it's not done by law. Commissions are done by the legislature and is done according to law. So let's see. He says appointments are politics. Commissions are law. I've been reading a lot lately, and we're going to go over a few things so you can completely and totally understand your remedy. There's one paper, I believe, that will remedy you from all non-positive law contracts when they try to bring you to court. Commerce and trade, customs and duties, education, food and drugs, foreign relations and intercourse, hospitals, asylums, Indians, internal revenue code, intoxicating liquors, labor, mineral lands and mining, navigation and navigable waters, crime control. Okay, so you get the idea. One paper will remedy you from any of the courts of non-positive law. Why? because it's political. Non-positive are political. Positive are law. Positive titles are law. They have positive law. Citation. All laws must have a citation. These things, Title 26, are politics. In other words, let's see what it says about politics. This is from a Chambers dictionary. The Chambers Dictionary. I have a dictionary, a thesaurus, and a etymological dictionary. But let's look at the word politic. In accordance with policy, political, relating to parties and their different views of government. Their views then are interpreted in courts. So policies are views that are different views from different parties. And so you go to court, and one judge might say, well, I think it's this, and another judge might say, I think it's that. And so they're interpreting the laws, whereas in accordance with the Constitution and the original oaths, the justices were to administer the law. They administer the law and they interpret policy. That seems to be the answer we're looking for. Okay, hold on, I'm not done. And I'm going to seal the deal, I think, at the very end. Let's see. Tax courts. Taxes are without a positive law citation. No positive law citation, right? Not a law. It means it's policy, it's contractual. The laws are or these policies are interpreted, the contracts are interpreted by the courts. All these judges, do you think they're commissioned, which is law, or appointed, which is policy or contract, social contract? These are all according to Google, according to ncsc.org. They are appointed. Tax court judges are, according to this, appointed, not commissioned. So what does that mean? There's a remedy to move things from courts and judges appointed to courts and judges commissioned. Okay? Because commissioned are law, appointments are policy or social contract, and law have a citation, policy or contract or social contract does not have a citation. Okay, so let's see if we can seal the deal here. Let's see real quick. Show you a little video here of Judge Napolitano talking about how to move things from one court to the next.
You need to really tell people what's going on also with these college students and how you mentioned over here that a New York City college student who was a permanent resident now sits in jail in Louisiana.
A federal judge ordered him brought back, and the feds have have ignored the order. So there is a hearing going on in New Jersey over whether or not his confinement is lawful, and a hearing going on before an immigration court judge in Louisiana over whether he can be deported. The federal judge in New York issued an order prohibiting the deportation. That's still a valid order. The federal judge in New Jersey has not interfered with it. But Gerald, let me tell you about these immigration courts. The immigration judge is not even always a lawyer, much less a judge, but he does or she does put on a black robe, and she works for the prosecutor. The judge works for the prosecutor. The prosecutor is Kristi Noem, not physically in the courtroom, but the Department of Homeland Security is the prosecutor. The immigration court judge, in quotes, works for the Department of Homeland Security. The appeal from the decision of the immigration court judge goes to the Secretary of the Department of Homeland Security. This is as rigged a system as there ever was. That's why lawyers are filing these habeas corpus applications, basically forcing the government to justify the confinement of their clients before real federal judges who are not subject to the Department of Homeland Security.